So today we are looking at Plessy versus Ferguson. And this is a court case from the Supreme Court of America, and it happened in 1896. This says abridged. Abridged means shortened. So what we have here is the shortened version. You have not got the full version here. So you can be grateful I did not give you the full version. It will be a lot longer. This is the short version. You don't need to know that, but you don't really need to know, but if you ever see that word abridged means shortened. They've taken out some of the detail to make it easier for you. Plessy versus Ferguson was a court case that was based on an action in Louisiana. And in Louisiana, Mr. Plessy was on a train, and he was 7/8 white, 1/8 black, and the conductor on the train told him he had to leave the white area. He had to go to the Negro area, the black area. And he refused, and he got arrested. And the judge, Mr. Ferguson, said the conductor was right, the Louisiana law is clear. And so this went to the Supreme Court. It went to the Louisiana State Court, and then it got upheld again to the highest court of the country, which was the Louisiana Court, the Supreme Court. It's a very famous case because it focuses on the equal but separate. And equal but separate was the idea behind the Jim Crow laws. The Jim Crow laws were, okay, we have these amendments, the 13th ending slavery, the 14th giving citizenship, the 15th giving people the right to vote. We have these laws, we have the Civil Rights Act, but how about if we have separate places for the black and white people? If we have one for the black and one for the white, can we say it is equal? Can we segregate? This court case is what gave people the right to segregate, to separate the black from the white people, because the Supreme Court had said this is okay. Now you'll notice that in the introduction it says one person disagreed, one judge disagreed. Now when you have judges in the Supreme Court, at the moment I think there's 9 judges in the Supreme Court. So if you get 5 judges agreeing, that is the decision. You need a majority. If somebody disagrees, then at the end of the court case, the majority will write down the decision of the court, and they will write down the reasons for the decision that the court has made. But if somebody is disagreeing, that means if they dissent means not agree. So if they dissent, they are also free to write down the reasons why they don't agree. And it can be put behind the reasons why the court agree. What we have here, starting on page 299, going on to page 300, 301, 302, is the decision of the court. This is the decision that the court came to, and the reason why the court made that decision. So referring back to the Constitution, to the amendments, they are showing the legal reasons why they make this decision. At the very end of page 302, there are 2 single-line paragraphs. Yes? The first one says, the judgment of the court below is therefore affirmed. So this means the majority have agreed with this decision, with these reasons. And then the next line says, Mr. Justice Harlan, dissenting. Mr. Justice, when you've got that new name, Justice, it means Supreme Court Judge. Okay? So because it says Mr. Justice, it means he is a Supreme Court Judge. His name is Harlan, but he is a judge. and it says he is dissenting. And so page 303, 4, 5, 6, 7, 8, this is the opinion of one judge, Judge Harlem, who does not agree with the other judges. He does not agree that separate but equal is okay. So the end of page 302 to the end of page 308, this is just his opinion on why the other judges were wrong. This part is not so important for the GED exam, because this did not become the law. The part that's really important is page 299 to page 302. This is the decision of the majority of the judges explaining why separate but equal is now okay. And this would stay until 1954, when the Supreme Court make a new decision in the case of Mr. Brown versus the Board of Education in Topeka. So this decision would stand from 1896 to 1954. So for the next 58 years, the country would have to follow this decision. Let's have a look at the first 4 pages. The Statute of Louisiana, the statute of means the law of. Statute always means law. So the law of Louisiana, Acts of 1890, Part 111, requiring railway companies carrying passengers in their coaches in that state to provide equal but separate accommodation for the white and coloured races by providing 2 or more passenger coaches for each passenger train. So this says there is a law in Louisiana from 1890 that says railroad companies must have separate but equal places for its passengers. There must be 1 car or more for the white passengers and 1 car or more for the coloured passengers. Coloured meaning not white. Notice it doesn't say Negro, it says coloured. So it's saying anyone who is not white. So Negro, yes. The African American, yes. Those that are half and half, maybe 1 white parent and 1 African American parent, they would also be not white, they would also be coloured. So the law is very clear, it separates whites and everybody else. It says that the other option is to divide the passenger coach with a partition so as to secure separate accommodation. So it says either there must be separate car, or in the car there must be a partition, a wall, to separate into 2 places. And providing that no person shall be permitted to occupy seats in coaches other than the ones assigned to them on account of the race they belong to. So the law says nobody can go to a different car of the train apart from the one that they are told to sit in because of their race. So their race will decide which part of the train they are allowed to sit in. That's what the law says. And requiring the officer of the passenger train to assign each passenger to the coach or compartment assigned for the race to which he or she belong. So on the train there is an officer or a conductor, somebody who works for the train company, and their job is to put people in the part of the train where they belong because of the colour of their skin, because of their race or ethnicity. And imposing fines or imprisonment upon passengers insisting on going into a coach or compartment other than the one set aside for the race to which he or she belongs. It says the officer of the train company must give a fine, a punishment, must take money from people who refuse to go to the part of the train where they are told to go to because of the colour of their skin. And conferring, giving officers of the train the power to refuse to carry on the train passengers refusing to occupy the coach or compartment assigned to them. It says the officer of the train can refuse to allow somebody to travel on the train if they refuse to sit in the area where they're supposed to be. So in summary, the law of Louisiana says train companies must have separate places for black and white people. The officer of the train company must show people to the right place, to the black area or the white area. If people refuse to go to that area, then the officer of the train company can punish them by taking their money, by taking a fine. Or, if they still refuse to go to the correct area, the officer of the train company is allowed to throw them off the train, to refuse them to travel on the train. That's what the law of Louisiana says. And then it says, these laws are not in conflict with the provisions either of the 13th Amendment or of the 14th Amendment to the Constitution of America. Okay. The last three lines, do you see that? This says, the first part of the paragraph, this is a really long sentence, that this says, this is what the law in Louisiana says. This says, Louisiana has a law talking about separate places for black and white people on the train, and the officer of the train company has to put them in those places. The officer has to punish them if they refuse to go to other place, and the officer has to throw them off the train if they refuse to go to the place. And the last part says, this is not breaking the 13th or 14th Amendment to the Constitution. The law of Louisiana making separate place for black people and white people does not break the Constitution, does not break the 13th or the 14th Amendment of the Constitution. So if you like, this is the decision. The Supreme Court says this law does not break the Constitution. That's the first page. As we turn over, we are going to get an explanation. Okay? We have the decision first, that this does not break the Constitution. And now we are going to get the explanation for why this does not break the Constitution. Nathia? This was a petition for writs of prohibition and certiorari, originally filed in the Supreme Court of the state by Plessy, the plaintiff in error, against the Honourable John H. Ferguson, Judge of the Criminal District Court for the Parish of Orleans, and setting forth in substance the following facts. This was the petition, this was the case of Plessy, who was the plaintiff. He is the one that is accused of doing something wrong. And he had been in the court of Orleans in the District of Louisiana, and the judge had been the Honourable John Ferguson. So, The person who was accused of doing something wrong was Plessy. The judge was Ferguson. This was in New Orleans, in Louisiana, before it was raised up, before it was appealed to the Supreme Court. The petitioner, that is Plessy, the petitioner was a citizen of the United States and a resident of the state of Louisiana. So he is a citizen of America and he is from Louisiana. Of mixed descent. That means he has got different ethnicity in his blood. In the proportion of 7/8 Caucasian and 1/8 African blood. Caucasian means white. So he is 7/8 white and 1/8 African American. So his mother and father were mostly white. Yeah? One of them would have been completely white, and their parents would have been completely white, and their grandparents would have been completely white. So you had to go back 3 generations in his family, and you would find that there was one black person 3 generations ago. His great-grandparents, maybe the father found a black slave. Yeah. Probably what would have happened, because the slaves, they would never fall in love with a white person, because the slaves were the property. So probably the owner of the slave, 3 generations before, maybe the male owner decided he wanted to have sex with the woman, and so he forced the woman to have sex, maybe rape. And so the child that would have been born would have been half black and half white. And that child would have married somebody white. And they would have had a child that would have been 3/4 white and 1/4 black. And they married somebody white. And you ended up with Mr. Plessy, who was 7/8 white, almost completely white, but he had a little bit of African American blood in him from 3 generations ago. So, the court case says he was of mixed descent, meaning somewhere in his family there was a black person. It also says that the mixture of colored blood was not discernible in him. Not discernible in him, which means you cannot see it very easily. If you look at him, maybe you think he's completely white. You cannot see easily that he is 1 part black. And that he was entitled to every recognition, right, privilege, and immunity secured to the citizens of the United States of the white race by its constitution and laws. He thought he had every right to be treated like a white person. He should not be treated like a black person because he was mostly white. On June 7, 1892, he engaged and paid for a first-class passage on the East Louisiana Railway from New Orleans to Covington in the same state. So he bought a ticket to go in the first-class train area, to go in the expensive white area of the train, to go from New Orleans to Covington, These are two places in Louisiana. And thereupon entered a passenger train and took possession of a vacant seat in a coach where passengers of the white race were accommodated. So he got on the train, he found an empty seat in the white area, and he sat down. The such railroad company was incorporated by the laws of Louisiana as a common carrier, and was not authorized to distinguish between their citizens according to their race. Now, Plessy says that the railroad company should not be allowed to separate between black and white people. He says it is not allowed. But notwithstanding this, the petitioner was required by the conductor, under penalty of ejection from said train and imprisonment, to vacate said coach and occupy another seat in a coach assigned by the said company for persons not of the white race. So the officer of the train, the conductor, he walked down the train, he checked the tickets. When he got to Plessy, he said, "You are not white. You should not be here in the white area. Come with me. Come to the area of the train for the colored people." That's what the guy said. And this was for no other reason than the petitioner was of the colored race. He said, and they're saying, because he is not pure white, because he is not completely white, he is not allowed to stay in the white only area. He is not white only, he is a little bit black. So the reason is he is a little bit black, he must move to the area for the colored people. That upon the petitioner, that's Plessy, upon Plessy's refusal to comply to follow with such order, he was, with the aid of a police officer, forced to be removed, forcibly ejected from the coach, and hurried off to and imprisoned in the parish jail of New Orleans. So because he refused to move, the train conductor, the officer on the train, called the police. The police got onto the train and by force pulled Plessy off the train and took him to the jail in New Orleans. And there he was held to answer a charge made by the officer to the effect that he was guilty of criminally violating, breaking an act of the General Assembly of the state approved on July 10, 1890, in such case made and provided. So the police officer said the government, the state of Louisiana, had made a law that train companies must separate the black and the white people. Mr. Plessy refused to follow the law, so the police officer had to remove him and arrest him because he was breaking the law of Louisiana. The petitioner was subsequently brought before the recorder of the city for preliminary examination and committed for trial to the criminal district court for the parish of New Orleans. So he first went to the local court where they asked him questions, and then they sent him for a trial for a public court case in the district court of New Orleans, where information was filed against him in the matters above set forth for a violation of the above act, which act the petitioner affirmed to be null and void because in conflict with the Constitution of the United States. So, when he went to court, they said, "You broke the law of Louisiana." But Mr. Plessy said, that law of Louisiana is null and void. That law of Louisiana cannot be used because it breaks the Constitution of the United States. He says the law is breaking the Constitution of the United States. So he says the law cannot be used. And so that is why they've gone to the Supreme Court. The court said he was breaking the law. He said the law is not applicable. The law cannot be used because the law breaks the higher law of the Constitution of the United States. And so the court case goes to the Supreme Court, where they will give their reason why it does or why it does not break the Constitution, the amendment. Remember, in their introduction, they already said it does not break the 13th or the 14th Amendment. This has been the introduction, the background to the case, so that people who read the decision understand what had happened. So, we go into the background. So we go into the decision. Mr. Justice Brown, after stating that the case, delivered the opinion of the court. This case turns upon the constitutionality of an act of the General Assembly of the State of Louisiana, passed in 1890, providing for separate railway carriages for the white and the coloured races. He said the key, the most important part of this case of Plessy versus Ferguson is whether the law that Louisiana made is constitutional or not. Whether the law of Louisiana separating the black and the coloured people on the railway breaks the Constitution or not. The constitutionality of the act is attacked upon the ground that it conflicts with both the 13th Amendment of the Constitution abolishing slavery and the 14th Amendment, which prohibits certain restrictive legislation on the part of the states. So they're saying it is especially about Amendment 13 and Amendment 14. In the whole of the Constitution and all of the amendments, these are the two parts that are relevant to this case. And you should remember, 13th Amendment abolished slavery, 14th Amendment gave them citizenship and equal protection under the law. 1. It does not conflict with the 13th Amendment, which abolished slavery and involuntary servitude except as a punishment for crime. Is too clear for argument. That it does not break the 13th Amendment is so clear, there is no reason why we should argue. Slavery implies involuntary servitude, a state of bondage, the ownership of mankind as a chattel, or at least the control of the labour and services of one man for the benefit of another. Slavery means one person has to work. They have no choice. It is involuntary. There is no choice. There is a state of bondage. They are bonded. That means tied up, if you like. They are tied to another person. They are not free to go. They are owned by another person. Or the other person controls their labor and their services for their own benefit. And there is an absence of a legal right to dispose of his own person, property, and services. So if you are a slave, you are not free. You cannot go where you like. You cannot own what you could like. You cannot do what you like. You belong to another person. A statute or a law which implies merely a legal distinction between the white and the coloured races. So a law which says there is a distinction, a difference, or a separation between the white and the coloured races. The distinction which is found in the colour of the two races, and which must always exist so long as white men are distinguished from the other by colour, saying there is always going to be black and white because you cannot change the colour of their skin. I talk about the white people and the coloured people. So there is a distinction, there is a difference, because their skin colour is different. So there is a difference. Has no tendency to destroy the legal equality of the two races. Just because I say black people go one place and white people go another place does not mean they are not equal. That's what the judge is saying. Just because the law says there must be one area for black and one area for white is not saying that they are not equal. It's saying that there is a distinction, that there's a separation. And it does not re-establish a state of involuntary servitude. Saying there is a black area and a white area does not mean that the black people are now slaves. They do not need to start working again for free. They will not be owned by somebody else. Indeed, we do not understand that the 13th Amendment is strenuously relied upon by the plaintiff in error in this connection. He says the judges, the court, they think it is wrong to use the 13th Amendment here. This is not about slavery. This is not about working for free. This is not about freedom for giving your work or keeping your work. This is about separating between black and white. So, the judge says the 13th Amendment is not relevant. The 13th Amendment ends slavery. Separating black and white people does not make slavery come back again. So, it is not breaking the 13th Amendment. 2. By the 14th Amendment, all persons born or naturalized in the United States are subject to the jurisdiction thereof, are made citizens of the United States and of the state wherein they reside. Anybody born in the United States or who's naturalized, who's lived here for a long time, is a citizen of both America and the state where they live. So they are, in this case, a Louisiana citizen and a citizen of the United States of America. And the states are forbidden from making or enforcing any law which shall abridge, which shall limit the privileges or immunities of citizens of the United States. So the state cannot make any law to limit the privilege of being a citizen, or deny to any person within their jurisdiction equal protection of the law. So you cannot give justice unequally. You must give both black and white people justice. Can you guess where this is going? What would happen if the white person sat in the black area? They would also be arrested, because the 14th Amendment says you cannot deny people equal protection under the law. You must follow the law equally for black or white people. So where this is going is they're saying you have a space for black people, you have a space for white people. The black people cannot go into the white area, otherwise they get arrested. The white people cannot go into the black area, otherwise they get arrested. So there is equal for both. And there is equal punishment for both. But of course, how many white people wanted to sit in the black area? No one, because the black area was horrible. The black people might want to sit in the white area because it would be nicer. The chairs would be wider, more comfortable, more space. So the black people might want to sit in the white area, but the white people would not want to sit in the black area. The whole way that the train was designed was about the difference between them. The object of the amendment was undoubtedly to enforce the absolute equality of the two races before the law. So the 14th Amendment is to say that black and white people are equal under the law. That's what the judge says. or But in the nature of things, it could not have been intended to abolish distinctions based upon colour, or to enforce social as distinguished from political equality, or a commingling of the races upon terms unsatisfactory to either. He says the law is to make them politically equal. So they are citizens, they can both vote, they both have the right to buy property. But the law could never try to force black and white people to mix together, commingling. So it's about political equality, not about social equality. The law could not be used to change people's attitude. It cannot be used to make white people like black people or black people like the white people. The law can only be used for political rights as a citizen of America, not to make people mix together or socialize together. Laws permitting, allowing, even requiring their separation in places where they are liable to be brought into contact do not necessarily imply the inferiority of either race to the other. Just because you make a law separating them does not mean that you are saying one is lower than the other. That's what he says. It does not mean that you are saying one is inferior. Now, that sometimes comes up later, and next to it would be a quote from the Board of Education versus Brown, where the Board of Education says, separating based on the colour is inherently unequal because people will grow up thinking that there is something bad about them because of their colour. So you will be asked to find why do they have different opinion. Here it says, just because you separate does not mean that you think one is lower than the other. Later they would say, if you separate only because of their colour, then it is sure that you are showing you think one is less than the other. And have generally, if not universally recognized, as being the competency of the state legislature in the exercise of their police power. Normally, this is a decision for the state. If the state would like to separate, that is within their authority. They can do that. They have the right. The most common instance of this is connected with the establishment of separate schools for white and coloured children, which has held to be a valid exercise of the legislative power even by courts of states where the political rights of the coloured race have been longest and most earnestly enforced. This says all courts in the country, all state courts have agreed it is right to have separate black and white school. There is nothing wrong with this. While we think that the enforced separation of the races, as applied to the eternal commerce of the state, neither abridges the privileges or immunities of the coloured men. So we think that making separation does not take away any freedom from the coloured man. It does not deprive him of his property without due process of law. It does not deny him equal protection of the law. So separating for business, for trade, just because of the colour of their skin, does not take away their freedom, does not take away their property, does not deny them justice. So we consider the fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the coloured race with a badge of inferiority. He says that the fallacy, the mistake, is that Plessy thinks by separating black and white people, the state is showing that black people are lower, they are inferior. This is a mistake in what Plessy is thinking, according to the court. If this be so, it is not by reason of anything found in the act, but solely because the coloured race chooses to put that construction upon it. If so, it is not because the law said one is lower than the other. The law only said they must be separated. It did not say one was lower or one was higher. If Plessy believes that means the black person is lower, it is only because he chooses to believe that the black person is lower. There is nothing in the law and there is nothing in the Constitution which breaks the law. That is what the judge says. Going down to that last paragraph on page 302, legislation is powerless to eradicate racial instincts or to abolish distinctions based upon physical differences. The law cannot stop separation just because people are different. And the attempt to do so can only result in accentuating the differences of the present situation. If we try to use the law like this, then the differences will get bigger and bigger. There will be more separation, not less. If the civil and political rights of both races be equal, one cannot be inferior to the other. If they have the same rights to vote, if they have the same right of citizenship, then neither is lower. They are equal. If one race be inferior to the other socially, the Constitution cannot make them equal. The Constitution is only about the Constitution is only about political rights, not about social rights. Okay? What they're saying is, for example, we can give everybody the right to freedom, everybody the right to be equal, but we cannot make everybody friends with each other. Whether you are friends or not, whether you meet together or not, is not up to the law, it is up to you. The law is only about your right as a citizen. And separating you on a train does not take away any of your rights as a citizen. That is what the Supreme Court said in 1896, and that is why from 1896 until 1954, America followed segregation. Nathia? Because of what the Supreme Court said, every area of America was allowed to separate black and white people. Okay, we'll stop there.